victims on the Zoom call. Date and time set for a case management conference. Mr. Brewer, as far as your case goes, did you get the court's information regarding your oral motion to withdraw previously?
I did, Judge.
All right. And I believe I've already addressed with the other parties this morning, making them aware of the court's ruling on that motion. Mr. Brewer, in the co-defendant's case, I also addressed on the record that the court will be granting the motion for joinder. Technically, I think that the order of the court will be under the rules. I'll remind myself, I believe 13.3 that subsection C, that this matter will be consolidated with Miss Woods. We're going to be generating a new case number, and both of these files will be transferred into that new case number. I don't have that number yet. My staff's been talking with the clerk's office regarding that. I will be issuing an order at least to provide the parties all of that. And that is done in the interests of justice and efficiency, honestly, in this matter. The other issues that we discussed previously, and we were on the record, but it was not in your case, Mr. Brewer, was just trying to find a time on Mondays where we could hold these consolidated hearings. I believe the preference for Mr. Lee as well as the state was perhaps an 11 or 11:30 setting on Mondays, when we very likely will be done with our calendar from the morning setting, but before your afternoon calendar settings, I would allow you to appear by Zoom if necessary for those. But I will address that issue first. Mr. Brewer, anything there would generally on your regularly scheduled Mondays, would an 11 or 11:30 setting work, and any other issues that you need to address with the court?
Judge, if I could take those in different order, just so I
Go ahead.
cover my bases. So I reviewed the court's ruling on the motion to withdraw. I feel there's still an issue. I also I filed a subsequent supplemental motion to withdraw. It's not ripe for now, and I understand that, but I filed that probably an hour ago.
All right.
With a request for some disclosure with regard to that. So my understanding of the ethical rules is, since the court has denied my motion to withdraw, I still need to proceed, and then that's what I will do. But I'm not waiving anything as far as that goes. I still want to, assert that issue. With regard to timing, I guess generally speaking, that's not going to be a problem for me. I'd like to know the dates when the court's planning on setting things, so I can be better prepared on that. But generally speaking, I think that will be, I can work with that. My request is going to be that the matter be set for a jury trial. We have, I believe, close to 90 witnesses. I believe that's going to take some time to get things prepared, but I believe the rule, well, I will invoke the Rule 8 rights on behalf of my client, which he is in custody. It's 150 days, which is 5 months, which I calculate from arraignment being around February 8th. So I would ask the court to set it within that time frame. Probably early February would be my request. I think that I would also ask that, because they're joined now, I assume the state is going to, and I don't want to assume anything, but I will make an assumption. I assume the state's going to begin assisting in scheduling interviews, so those can be conducted one time as opposed to multiple times. I think that would be more economic, but again, however the state wishes to proceed. If they're not going to assist, then I'll begin sending letters out to conduct my own interviews with all the witnesses. But if that's the case, then I probably won't be being as courteous of setting up times that are convenient to the state. So I just want to say that. Um, I am aware of the administrative orders that the court has regarding jury trials. I just think that this is a much different situation. Those administrative orders, basically, my analysis would be to preclude a defendant from asserting their Rule 8 until they are ready to proceed to trial, which is a lot of time to make that happen. And I don't think that's required under Rule 8. I think as long as the jury trial is requested and there's no additional time added, all that is included time. And so I am asking that we set this for a jury trial. If we set intermediate court dates, that's fine with me. I don't have any issue with that, but I would ask that we, I guess, go around the administrative order, because otherwise, I don't think the court could set a trial within a month when we say we're ready, especially with the number of jurors we're gonna have to have and all of that. So I think it just is better all around to have something set far out. And then if we get, within 2 or 3 months and we're having problems, someone may want to file a motion to continue. I have no idea about that, but I think it's something that we can still do without, totally wrecking the court's calendar and things of that nature. So other than that, Judge, I would ask for that to be set. I would invoke my Rule 8 rights. My client did receive his glasses, and I think the parties who were involved in getting that done. Other than that, Judge, I don't believe I have anything to add at this time. Thank you.
All right, thank you, Mr. Brewer. I'm also glad to hear about the glasses. I'll try to address all of those, and then I will go to the other parties. My intention that I stated previously to the other parties when we were on the record was that I will be setting at minimum a case management conference date. That might be by order when I get the case number, but we can talk about those dates now to make sure it's at a time that works for as many parties as possible. I will note that you have requested the jury trial to be set on behalf of your client and an intention to follow through with his Rule 8 time limits. I addressed on the record and ruled previously under Rule 8.2A3, as I read the informations in both of these matters, I believe that this does qualify as a complex case, and I believe the speedy trial time would be 270 days because of the first-degree murder charges under 8.2A3A. The parties, if they need to, can address that finding by the court with motions or whatever we need to do in the future. But from the court's perspective, I understand the requests. I think I will just be working very likely with that 270-day time limit. I do hope and appreciate the request that the state begin to assist with setting up interviews, and that is one of the reasons why I did the order consolidating, is for the interests of justice, including in a speedy resolution. And so I hope that the state also will work on setting those up and trying to do that as much as possible with all parties, at least both defendants, being able to attend and participate in the same interviews, so those don't have to be done for all of the parties' rights and interests multiple times. As for the request for a jury trial date, I will note that. I have noted it for the record. I think I will wait until our first consolidated hearing at a minimum to actually give a date, so that all of the parties can weigh in regarding that and to look at their schedules in the next, or the 270 days from arraignment, which I believe was 2 weeks ago. On that note, Mr. Brewer, the availability as far as between the calendars, next time I have on the 14th of October Actually, did I set any hearings with you on Monday, September the 29th?
You did, Judge.
I think I did as well with Mr. Lee, though I'm not 100% sure about that. But I would like to look for that date and probably preliminarily set our next case management conference possible trial setting date for Monday, September the 29th. That's just in 1 week's time. I believe we could set that at 11:30 a.m. with council, all council being able to appear by Zoom if necessary. I would ask council to come prepared that day to address any updates regarding length of trial and also their availability for trial dates. As to the request regarding the administrative order of the court, I understand and agree with that position. I haven't heard from the state on that. I'm not sure if they're up to speed on that, but I think because the court has found that this is a complex case, I won't require the specific compliance with the court's administrative order regarding the setting of trial dates in this case. I agree with Mr. Brewer that I don't believe it accomplishes its intention in a case like this for a number of reasons. Won't go through all of those right now, but my intention right now is not to require either from the state or from the defense the specific requirements of that administrative order. I will be following up with the parties and hope to address the issues that are addressed there, but not require that. Again, it's strict compliance with that requirement. With all of that stated, apologize that was too much. Ms. Collins, anything that you need to address, all of that you need to address, go ahead.
Judge, I don't think there's a lot for us to address. I think the hearing next week, the state will be available. We can obviously check with Ms. Clace as well. I would concur with the court that under the Rule 8.2 A3, the 270 days are there to work with as opposed to the 150. So, and I believe because it's first degree murder, it's not a written finding circumstance, which we deal with in other complex cases. But because of the first degree murder charges, I think your ruling and finding is sufficient. So from that perspective, Judge, we will be ready to set trial dates next week. Regarding setting up interviews, pretrial interviews, yes, we will absolutely work with the defense counsel for both defendants in trying to be as efficient as possible. So that will not be an issue. And in part with us giving the witness list, that was us trying to get ahead of this as quickly as we could, given the circumstances.
All right. Thank you, Ms. Collins. Ms. Clace, do you need to address any of those issues that we've addressed, especially availability for next week?
Your Honor, I can be available on September 29th. Thank you.
All right. Thank you. Mr. Brewer, is there anything additional you need to address after I kind of went through and tried to address all of your issues for today?
No, Judge.
All right. So we have set that hearing. It'll be in our new case number. We will send out in a bench order with that case number and going through the details of what needs to happen from the clerk's office in joining these two cases to that new case number. I assume there will be a designation of one of the defendants as 001 and one of them as 002 or something along those lines as we've done in the past. I believe, I did see Mr. Brewer. I don't know if you saw Mr. Lee filed a request for a preliminary hearing transcript I ordered this morning. We've already started on that process in my office. I've ordered this morning that will go to all of the parties when it is prepared, and that we'll try to get that prepared as soon as possible.
Thank you, Judge.
I, of course, have not seen, but I will review the written motion to withdraw that you filed today, and I will try to be, of course, as timely as possible regarding those motions. I believe those are all the things I needed to address. Anything additional from any of our parties for today?
Not the state, Your Honor.
All right, thank you. We'll be adjourned in this matter.